Okay, so in this video, I'm going to talk about different types of legal liability. So we're going to have three types of legal liability: breach of contract, criminal offenses, and torts, which are civil wrongs. So for breach of contract, liability insurance is not going to cover that. And the reason for that is, I think the presumption would be if you signed a contract, then you have agreed to a certain behavior and you knew what was happening and you chose not to do it. And so legal liability insurance is not going to cover that. Criminal offenses, similarly, there are certain activities that are illegal. And so if you engage in illegal activity, the liability insurance is not going to cover that either. So that brings us to the last category, torts or civil wrongs. So this can involve types of activity which are not criminal, often involving some aspect of negligence or something of that nature where somebody was harmed. Generally, there wasn't necessarily the intent to harm, things like that. So let's add a little bit more detail to that. The first kind of point to discuss is what's called intentional interference. So this can be either criminal or civil. So if it's criminal, then it's not going to be covered. But if we have intentional interference that is not criminal, like slander and libel, so slander and libel are generally going to be covered. So somebody has harmed somebody else. It wasn't criminal activity, but harm was done. And so that would be under the intentional interference category, and then that would be covered. Okay, so let's talk about strict and absolute liability. For strict liability, one example of that would be workers' comp. So if an employee is injured at an employer's place of employment, then the presumption there under strict liability is that the employer is responsible pretty much no matter what. Now, in some contexts, there might be slight shades of difference between strict and absolute liability, but in many cases, they're pretty much interchangeable. And the basic idea is with strict and absolute liability that some party is held liable absolutely, regardless of who did what, basically. That brings us to the next topic, which is negligence. So for negligence, one of the things that's often going to matter is what's called the prudent man standard. And the idea there is if a prudent person would have done something that would have mitigated or eliminated the risk involved that led to the damage or injury, then the person who did not do what the prudent man would have done is considered to be negligent. So if a prudent person would have trimmed a tree and therefore wouldn't have had a whole bunch of dead branches that could have then fallen on somebody else's car, then basically the person who didn't trim the tree is considered to be negligent. They didn't do what they should have done to have reduced that risk, and therefore, when that person parked the car on the negligent person's property and the branch fell and damaged the car, that is essentially the responsibility or liability of the negligent individual. So that's kind of the idea. Now, one of the other aspects of this is indirect or vicarious liability. And so this is one in which the employers are held liable due to the actions of employees. And so the idea there is that because the employee is acting at the behest of the employer, if the employer does something, if the employee does something, the employer is held liable for that action. So even though it wasn't the employer specifically, they are held indirect or vicariously liable. So that also brings up the fact that there are certain areas in which strict or absolute liability actually applies to certain types of activities. So that are basically so inherently dangerous that whoever's engaging in the activity is considered to be liable, sort of regardless of what happens. So as sort of an example of that, if somebody is using explosives as part of their job, and this may be a part of the actual normal procedure for the job, but they're using explosives, I think mining or something like that, that is such a dangerous activity that the person who is using them is considered to be strictly or absolutely liable typically. Now, another important definition is negligence per se. So negligence per se is basically considered to be a situation in which the action itself proves the negligence. And so it isn't necessary to separately prove negligence. The action involved proves it. So as an example of that would be drunk driving. And basically the idea there is you don't have to prove negligence on the part of the drunk driver. The fact that somebody was drunk and behind the wheel of the car driving is basically by definition or by the action proves it. That's negligent. That person should never have been behind the wheel driving while drunk. And so the action itself shows it. The person who was injured doesn't have to prove negligence once they've shown that the person was in fact drunk. And there's actually a legal term for that, and that's res ipsa loquitur. And it's basically the idea is that the action itself has demonstrated this. Now, when damages are involved, typically what is going to be associated with liability would be some form of bodily injury or property damage. So that's typically what's going to be associated with the damages in a liability scenario. Now, one of the things that's kind of interesting is that there is a collateral source rule. And basically what this says is that even if the injured party has insurance of various forms or disability insurance or what have you, that does not reduce the damages that are awarded to the injured individual. And if you think about it, that kind of makes sense, because if you rely upon the injured individual's insurance, that kind of means the negligent party is not held as responsible. So under the collateral source rule, basically what's happening is the person who's negligent is going to have to pay up for the damages, regardless of what the injured individual has in terms of other insurance or what have you. Now, there are some defenses to claims of negligence. So one of them is assumption of the risk, and that is that the injured knew the risks. So if, for instance, maybe you go skydiving and you signed a waiver saying, I know that it's risky, things could go wrong and it could end very badly. You're sort of assuming the risk associated with a lot of those activities. And so that would be a potential defense to negligence in claiming if somebody was injured and then they tried to claim negligence on the party of the person who took them skydiving. And obviously the finer points of the situation may affect to what extent that argument is or is not successful, but that's kind of the idea. Contributory negligence would be a situation in which the injured party doesn't or didn't act appropriately and so therefore contributed to the outcome. And because the injured party contributed to the outcome, then basically what that would mean is that not all the responsibility lies with the person who is being accused of negligence. Another defense to negligence would be comparative negligence, and this would basically be to examine the cause of the outcome and try to assess what percentage of the cause was due to the injured party and what percentage of the cause was due to the person who is being accused of negligence. And basically the damages awarded would be adjusted relative to who contributed how much to the cause, basically. There's also the last clear chance rule. And that would be one in which that applies if the defendant had a last clear chance to avoid. And so if somebody is being sued for negligence and the person who is being sued for negligence, the defendant, had a last clear chance to avoid the situation, then obviously that would be bad for the person being accused of negligence. Okay, hopefully this video about some of the different types of legal liability have been helpful. Thank you for watching and have a great day.